crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts with host David Lamb and the attorneys of Hollis Wright.
Good evening and welcome into the attorneys. Thank you for joining us tonight. Got a really interesting panel here for you of some experts talking about some legal matters that I promise you'll be interested in. Trust me on that. But first, some ground rules. We'd love to have you join our conversation all throughout the program. At the bottom of your screen, there are ways you can call, text, email, whatever you prefer. We try to make it easy for you. Also, Hollis Wright does this really neat thing. Every time the attorneys are on the air, there are some attorneys from Hollis Wright standing by live. So 844-LAW-TALK is the number to know. Just call that number. That's a free, off-air, and confidential conversation that is yours for the taking, an opportunity for you that Hollis Wright makes available. Leading our conversation tonight is Carter Clay from the firm Hollis Wright. How are you, sir?
I'm doing great, David. Hope you're doing well.
I'm doing well. Thank you, sir.
Good. Yeah, I'm really excited about tonight's show. One of the favorite shows that I like to do involve not necessarily topics, but guest.
Right.
And what I'm talking about there is the guest that we have tonight has a more diversified background than I do in this respect. I've been practicing over 20 years in personal injury law, but exclusively representing people that have been injured or families that have lost a loved one in an accident. Mm-hmm. We've got Maridi Huggins here tonight, and she has been on both sides of the fence. Yeah. So she's now practicing personal injury law, representing individuals who have been injured in accidents, but previously I know that you were on the defense side. So you were defending individuals or companies that perhaps we have sued, and I know over the years you and I had cases against one another. Yep. So she's a bright mind in this area, David. I'm super excited, Maridi, to have you on the show. Thank you so much for being here with us tonight.
Thanks for having me. I'm happy to be here.
Yeah, well, tell us a little bit about, I guess, your career practicing law so far in terms of defending cases and your transition to actually representing people who have been injured.
Sure. Well, I've been practicing law for almost 13 years. I started practicing a couple of larger defense firms downtown, doing primarily car wreck litigation defense, slip and fall defense. About 5 years ago, I made the decision to take the leap, go out on my own. So I have Maridi Huggins Law now, and we do exclusively personal injury. So like you referenced, I've switched sides, and now I advocate for people that have been injured in primarily automobile accidents, slip and falls. And so it's been a great transition, but having been on the other side, it was definitely, that experience was helpful for me in what I'm doing now.
Yeah. So when we talk about civil law, that's a broad topic, but when we narrow down a little bit and we talk about civil personal injury law, what are just sort of the particular areas of civil personal injury law that are potentially out there to individuals and sort of the areas in which you practice?
So with my firm, we handle primarily auto insurance, automobile litigation, auto accidents, trucking accidents. We also handle a few slip and falls. If the facts are right, we may get into that later tonight. You really have to look at those cases with a careful eye. But some other cases that are out there, you've got wrongful death where someone has passed away as a result of maybe an automobile accident or a trucking accident. Products liability is another popular area where there's a lot of litigation ongoing. Medical malpractice. My firm doesn't do med mal. We'll refer those out to larger firms like Hollis Wright. But my focus is primarily the automobile accident litigation, because that's what I did on the other side. I feel like that's what I know the best.
Well, I always tell people, and I always tell the viewers, there are a lot of unique areas in which people get injured in everyday life.
Sure.
And what I tell people is that if you've been injured, and you've been injured as the result of somebody else's misconduct or neglect, call a lawyer and ask them if they think you have a case. Regardless of whether it fits into this classification of nursing home malpractice or product liability, just pick up the phone and call, because as you know, we give free consultations. We work off a contingency fee basis, and we're going to talk a little bit more about that. But I always tell people to come down on the side of calling a lawyer and just talking with them initially and asking them if this is a particular personal injury area in which they may have a case.
No, that's absolutely right. don't Google, don't try to figure things out for yourself. Don't get your law degree online. Call a lawyer. I mean, we're trained to, recognize if it's a case or not. And like you said, most law firms allow you to have a free consultation. I'm always happy, to speak with a potential client for 30 minutes, an hour, just to determine, do you have a case or not?
Right.
So it's always a good thing to explore your options. Don't go to the internet first.
Yeah.
Find a lawyer and call.
Well, let's give the viewers some tips on what they should perhaps try and do if they've been involved in a motor vehicle accident. So there are a lot of people out there that have been in a motor vehicle accident, had family members in a motor vehicle accident. What types of things or steps should they take if they've been involved in a motor vehicle accident? And let's start right there at the scene. Bam, they've been involved in an accident. What should they do?
Sure. Well, the first thing is, make sure that law enforcement's been called and that a police report has been filed and that the accident has been documented. And then, obviously if you're injured, tell somebody, tell the investigating officer, call 911. If you have the frame of mind to remember to take photos or talk to witnesses, if you aren't too hurt. Otherwise, call somebody to the scene and have them do that for you.
Yeah.
But it's very important to document exactly what happened. And the reason why is because when you get into a situation where you have the potential for litigation, you're going to want that evidence. You're going to want the photographs. You're going to want the witness's information. And that the investigating officer is not always going to take down that information. He or she is not always going to take those photographs. So do your best to document the scene. And then once you get your injuries taken care of, your medical treatment lined up, my recommendation is to call a lawyer.
Yeah.
Don't delay. Because the person that hit you has insurance more than likely,
right.
And that insurance company is going to have a claim representative that is already going to be working on that file. They're already going to be calling you, trying to get your recorded statement, and you're going to want a lawyer to advise you through that so that you don't make mistakes that can come back and then bite you in the end if you're having to sit on the stand and testify in front of a jury. You want the best case possible, and to have that, you've got to contact a lawyer early on.
Yeah, and I always tell the viewers or clients, look, go ahead and ask the other driver that you believe is at fault to provide you with their insurance card. They're required to provide it to the law enforcement. There's nothing wrong with you asking them, hey, do you have insurance? And if they say, yes, I do, hey, would you mind if I see your insurance card, snap a photograph of their insurance card so that you'll have that and be able to provide it to the attorney.
Right.
One other thing that I always tell people is, don't assume that the police officers, and you touched upon this, but I think it's worth repeating, don't assume that the police officer is going to gather and record all of the pertinent and relevant information at the scene. The vast majority of automobile accidents that occur, unless they involve a death or a serious personal injury,
right.
The officers are not going to take photographs. They're just not. They're not going to take photographs of the automobiles or the damage. They're not going to take photographs of the scene or the roadway. And so if you have the ability with your phone to take photographs of the damaged automobiles, take photographs of the scene, I think that's an incredible thing to do to help your case out and to help your lawyer. And the other thing I would do is, if you see witnesses or know of witnesses, get their information. I mean, how many times have you been involved in a case where the client says, I know there was a witness there,
right.
And they don't have the information and the witness is not identified on the police report, and that witness could have saved the case or proven the case.
Oh, and there have been countless cases that I've had where an independent, objective witness has been the influential factor.
Yeah.
Because your client, as a plaintiff, if you get to trial, you're going to be asking the jury for compensation. The defendant has skin in the game because they're going to be wanting to avoid responsibility. So who does a jury look to? An independent, objective, third-party witness that doesn't have a dog in the fight, right. That's going to relay the facts as they saw them. And if those facts are favorable to you, you want that person on the stand.
Yep.
Time for us to step aside right here. Let us take our break. More of the attorneys coming right up, so stick around. We are coming right back.
I'm Josh Wright with the law firm of Hollis, Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show 8 years ago, my hope was we would be able to do what we do best, which is to help people answer real-world legal-related issues they have in their life.
People oftentimes are confronting various legal issues and problems in their lives that range across the gamut of legal practice areas. Bankruptcy, criminal law, family law, just to name a few. And to be able to have a 30-minute platform or format to where we can just cover various legal topics once a week, that's obviously the primary focus of the show.
That we would be able to use the resources of the many lawyers we have at this law firm to create a plan that had a lasting impact that also gave back to the community at the same time. And I think we've done just that with The Attorneys.
Welcome back in to The Attorneys. Reminder before we get back to the questions, 844 Law Talk is the number to call to speak with attorneys from Hollis Wright who are standing by live to speak with you. 844 Law Talk. A question we've got here. I was recently in an accident where I was injured on someone else's property. I've learned that other people were injured before me due to the same condition. How will this affect my case, if at all?
So positively,
Right.
if I were to say one word, that is, slip and fall cases in Alabama are very hard to prove. And most firms, I would think, at least my firm, we are very particular in terms of the types of slip and fall cases that we take. And during intake, I'm very thorough in terms of asking the potential client what happened because they are so hard to prove, and I want to make sure that I've got the facts to prove the slip and fall case. And one of those, the main question is, do you have any evidence that the landowner or the property manager had knowledge of the condition that caused you to fall? And that can be, found mostly with prior occurrences. And sometimes, you'll be surprised. You'll have a potential client that says, "Oh yeah, well, the manager mentioned that someone just fell over here the other day."
Yeah.
And so employees of the landowner will sometimes let it slip that there have been prior occurrences. Sometimes there's prior lawsuits involving the same defect that caused your potential client to slip. So, prior occurrences, putting the landowner on notice of a condition, absolutely, that is important to your case. So if you have knowledge of that and you're in a consultation with your attorney, make sure to mention that.
Yeah, those really fall under the umbrella of premises liability cases, which David, we've had a lot of shows involving premises liability, and the extent to which you can recover in those cases oftentimes is dictated by your classification on the property, whether you're a licensee or an invitee or a trespasser. But one of the universal truths, regardless of what your classification is that if you can show knowledge on the part of the premises owner that they were aware of the defective condition, even if somebody else had not been injured by that defective condition, if they knew about it, and certainly if they knew about it and somebody had been injured in the past, that is always going to make for really good proof in your particular claim against them. So the short answer is, like Maridi said, it will affect your case positively. It doesn't mean you absolutely have a case.
Right.
There are defenses, but it's certainly trending in the right direction at that point.
All right, good.
Yeah. Maridi, let's talk a little bit about burden of proof. In the civil cases, the burden of proof is different than in criminal cases. Can you talk a little bit about what that difference is and what it means for people that are injured?
Sure. Most people watch a lot of legal TV, and on most of those shows, the burden of proof that is articulated is beyond a reasonable doubt. But we've got two systems here. We've got a criminal system, we've got a civil system. On the criminal side, that is the burden of proof. But when we are in the civil side of things and we're talking about money damages, the burden of proof is significantly lower. And the legal term is preponderance of the evidence. But what that really means is as a plaintiff's attorney, as someone representing the person that is injured, my burden of proof at trial is more likely than not. So it has to be a little bit over 50%. I have to prove the elements of my case to the reasonable satisfaction of the jury. And so it's a lot lower than beyond a reasonable doubt. And so if I'm in trial and I'm questioning potential jurors, I want to go over that burden of proof to make sure whoever is sitting on my jury understands I don't have to prove my case beyond a reasonable doubt. It's much, much lower. It's preponderance of the evidence on the civil side.
Yeah, and I'll often ask potential jurors, do they think my burden should be beyond a reasonable doubt? Because obviously I want to flush that type of information out if somebody's inclined to hold me and my client or our case to a different standard. And sometimes I'll use the illustration involving the scales of justice.
Right.
I think everybody's seeing the scales of justice, and I will tell potential jurors that the way to look at it is that when you think I score a point, I get a pebble over here. If they score a point, they get a rock over there or a pebble over there. And if the scales of justice are tipping ever so slightly in our favor at the end of our presentation of evidence, then my client should win. And so I think that's a good way for people to kind of visualize what the burden of proof is in a civil case versus a criminal case.
Right, that's a good illustration. I may
use that sometime. Well,
If you don't mind.
I can sometimes give good advice here and there. Sure, absolutely. All right, let's talk a little bit about contingency fee arrangements. We touched upon that at the beginning of the show. What is a contingency fee arrangement, and what are sort of the typical contingency fee percentages that people can expect to have a lawyer propose to them if they're going to be representing them?
Sure. Well, pretty much the number one question that I get from potential clients is, how am I going to pay for this?
Right.
And the quick answer is you don't have to initially.
Yep.
Which is always something that is good for people to hear, because with the contingency fee arrangement and the way that it works out, I think it allows people greater access to justice, to attorneys. But the way it works is, so you sit down with your consultation. If your attorney decides to take your case, you go over your fee agreement, and in that fee agreement, the contingency fee is going to be laid out. It's somewhere between 33 and 45%. It's negotiable, but it's typically in that range. And so what that means is, when your attorney takes your case, the attorney handles everything, the expenses, and if there is a settlement or a judgment at the end, then the attorney's fee of whatever it was you negotiated in the fee agreement is taken from that settlement amount or from the judgment. So the attorney's fee is taken on the back end, and so you always hear the phrase, we don't recover unless you recover. But that's exactly what that means. If there is no recovery, then the attorney just eats the cost. It's sunk cost, and it's just the risk of what we do.
Yeah, and usually, David, the fee percentages will range anywhere from about a third or 35% up to 50% contingency fee arrangements, and that is really influenced or dictated by the complexity of the case and how much money the lawyer is going to have to advance or spend to prosecute that case. The greater the complexity and the more the lawyer is going to have to invest, the more they're having to risk, the higher the contingency fee percentage will be. And so I think that's good for the viewers to understand.
Yeah, makes sense.
Yep.
All right, let us step aside. This is our final break of the evening. So we've got one more segment remaining. As we head to break, a reminder about Hollis Wright and social media. Wherever you are on social media, they are as well. So check them out. Just search the term Hollis Wright. You'll find them on Facebook, YouTube, Instagram, Twitter, and whatever new form of social media is now out there. They're probably there as well. So just search Hollis Wright and you'll find them there. Stay tuned. More of the attorneys coming right up.
I'm attorney Carter Clay with Hollis Wright Law Firm. If you've ever been involved in a civil lawsuit or been a witness to an accident, then you may have been asked to give deposition testimony. In this week's Legal 411, we are answering the question, what is a deposition and why am I being asked to give one? Depositions involve the process of a person giving under oath testimony that is outside of court. The person giving deposition testimony is referred to as the deponent. Depositions are taken in the presence of a court reporter, and the court reporter records the testimony. After the deposition, the attorneys for the parties received a typed transcript that contains all the questions that were asked by the attorneys, as well as the answers given by the deponent. The purpose of taking depositions is to ensure that the attorneys for the parties have a full and complete understanding of the events giving rise to the lawsuit, as well as an understanding of the testimony that they can expect to hear from witnesses at trial. Another reason an attorney might want to get deposition testimony is that it allows the attorneys to better prepare for trial and to develop a strategy for presenting the case to a judge or a jury. At trial, the deposition testimony can be used in several ways. First, if a witness on the stand deviates from the deposition testimony, an attorney can use the deposition to impeach the witness. Also, if a witness forgets certain facts or events, the deposition can be used to refresh the witness's recollection. Finally, in some instances when a witness simply cannot attend trial, the trial judge has the authority to allow the deposition testimony to be read to the jury. If you are a party to a lawsuit and are requested to give deposition testimony, your attorney will likely spend a significant amount of time preparing you for the deposition process to put you at ease and make you feel comfortable. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys on WBTM 13.
Welcome back in to The Attorneys. About 6 minutes remaining in the show, so this is our final segment. So if you want to take advantage of the opportunities to speak with the attorneys from Hollis Wright who are standing by, 844-LAW-TALK, 844-LAW-TALK, that's the number to give them a call. Carter?
Yeah, Maridi, as you know, statute of limitations play a big role and part in the types of cases that we handle. There are statute of limitations that apply to all of these personal injury matters that we've been talking about. So let's tell the viewers, what is the statute of limitations for these types of cases, personal injury matters in Alabama, and talk about the effect of not complying with it.
Sure. So the main statute of limitations in Alabama is 2 years. That's going to apply to automobile accidents, slip and falls. The majority of what you see, 2 years. Some causes of action carry longer statutes of limitations. If it's a claim against a county or a city, there's a shorter notice time. So, you want to make sure that you have your date of injury documented so that when you talk with your attorney during that initial consultation, you get that out so the attorney can record it and make sure that if, the case has to go to litigation or something, that, a complaint with the court is filed by that statute of limitations date. You talk about consequences. If your claim is not preserved by the time that statute of limitations expires, your claim goes away.
Yeah.
And that's a big problem, not only for yourself, but also your attorney. If we as an attorney miss a date, that's bad.
Yeah.
So, you want to make sure that you have that date of injury documented and that you've talked about that with your attorney and that the attorney is on notice that, there's 2 years that we've got to get this either settled or file a lawsuit.
Yeah. I often tell people the biggest mistake they can make is not filing their lawsuit within the 2-year statute of limitations.
Right.
However, it's important for the viewers to note that the second biggest mistake is thinking they can wait to hire a lawyer because they have so much time.
Right.
And not only is that problematic from a statute of limitation standpoint, it's problematic from a fact-finding and investigative and evidentiary basis as well, because as you know, evidence can become stale, witnesses forget what happened, and so it's really important to hire a lawyer early on and allow them to jump on it quickly.
Right, and I mean, if, for example, if I've got a DUI case and I've got a really good witness, if I see that it's not going to end up in a good settlement with the insurance company, I'm going to want to go ahead and file that lawsuit so that I can get my evidence preserved, take the deposition of the witness, do whatever else I need to do to make sure that I have all the evidence so that if the case eventually goes to trial, I've got my evidence. Because as you said, witnesses can pass away, evidence goes stale. Cell phone records, a big thing in automobile accident litigation. And most cell phone companies don't keep data, beyond a certain period of time. So if I'm going to end up in a litigation situation, I'm going to want to be able to get those cell phone records. So the bottom line is don't wait. call your attorney, and then your attorney will make that decision for you, and will make sure your lawsuit gets filed at the appropriate time.
All right, let's talk a little bit about what we refer to as UM or UIM coverage, uninsured motorist or underinsured motorist coverage. What is that, and talk about just how important that is for people to have to protect themselves?
Sure. So I guess to sort of start that discussion, it's important to know that not everybody driving a vehicle is going to have liability coverage. In Alabama, the mandatory minimum is $25,000 per accident, $50,000 per occurrence, but some people let their policies lapse, some people don't purchase insurance to begin with. So, if you are in a situation where you have been hit by someone that doesn't have insurance for whatever reason, then you are going to need under your own policy what's called uninsured motorist coverage. And so that's there to cover you if you're hit by someone that doesn't have insurance. It's there to cover your medical bills, your pain, suffering, mental anguish, out-of-pocket expenses, lost wages. So you want that on your policy. That's uninsured motorist coverage. The other prong of that coverage that you pay for is underinsured motorist coverage. And what that is there for to do is if you get hit by somebody that doesn't have enough insurance, if you're catastrophically injured and your medical bills are through the roof, you're going to want enough underinsured motorist coverage on your own policy to help cover those expenses and make up the gap, because the person that hit you may only have the minimum of $25,000.
Yeah.
So you want to make sure you have that coverage on your policy. Don't reject it. It's automatically included unless you sign a specific form rejecting it. So make sure you keep that coverage on your policy. It's important.
Yeah, David, the premiums are not that much for the UM-UIM coverage, and like Maridi was saying, if you don't affirmatively sign away that UM-UIM coverage, then you've got it. So please do not sign that rejection.
We have less than a minute and a half remaining, but want to give you just a quick final thought. Maridi, if you would, you go first, please.
Sure. I think the big message, if you are injured, call an attorney. You're not going to be looked at negatively. People aren't going to think you're, being greedy. It is you doing your due diligence and protecting yourself. You need to talk with a professional to evaluate your situation, see if you have a case, and get it handled appropriately. So call an attorney.
Yeah, and I would say, again, don't assume that law enforcement or other people in authority are going to gather the evidence for you. If you're not injured that badly, or you have the ability or have a family member that can help you gather evidence at the scene, whether it be getting witnesses information, whether it be taking photographs at the scene, anything like that is going to prove to be invaluable to the attorney helping you.
All right. Good show.
Great show. Thank you, Maridi.
Thank you for having me. I appreciate it.
Thank you all for being with us, and thank you for being with us as well. As we wrap things up, I want to let you know 844 Law Talk, that number, you just need to write it down and keep that one close. That's the number to call if Hollis Wright can be of service to you in any way. Also, you can check out the website hollis-wright.com, where you'll find all the attorney shows and all kinds of helpful information there as well. Thanks so much for being with us, and we will look for you next time and next week right here on The Attorneys. Have a great week, everybody.
Thanks for watching The Attorneys, sponsored by Hollis Wright.